All right, as we continue through our trial process, we talked about the direct examination and the cross-examination. That is a type of evidence, witness testimony. Evidence is something that's used to prove the existence or non-existence of a fact in the case. And remember, we're dealing in facts. We're not dealing in opinions. It's not circumstantial, Casey Anthony. We're dealing with facts. So witness testimony is considered to be a fact. Now, keep in mind, take note, the jury can choose to believe or not believe witnesses based on their opinions, based on things that they've heard from other witnesses, based on how well they know the facts in the case. So a lot of that does depend on how prepared the witness is when they're making their testimony. So that's why on direct examination you want to be really prepared. On cross-examination you want to have as many answers as you can and make those answers make sense. The other thing that you deal with is what is known as tangible evidence. That's anything that's not testimony. So that includes like the murder weapon or reports or fingerprints or DNA or any of those other things, photographs, the outline of the crime scene, where all of those things are different pieces of evidence that are presented in the case. And remember, I told you can't present evidence that will bias the jury. So this is a great example. Philadelphia. Now, it is a civil case as opposed to a criminal, but the case was depending on AIDS and getting the jury to understand. Tom Hanks' character right here has lesions, which is a side effect of AIDS. And the defense said that they didn't know they thought they were just bruises. So the prosecuting attorney here, or the plaintiff, basically wanted to show the jury that defense argued that the evidence was prejudice. It would make them have sympathy, but the judge allowed it so that they could see the difference between what was a lesion and what was a bruise, so that you could see that it really wasn't something that was easily mistakable. And does that have some prejudice? Sometimes it does. So the judge has to weigh those things, prejudice versus the evidence there, the importance of the evidence. And that's always a difficult process for the judge, and something that can always be appealed as well. Now for the defense's job is to basically poke holes or disprove the prosecution's evidence. They will often ask for dismissal of the case to kind of tell the jury, hey, they didn't really have much of a case, which never happens, but that's okay. But the defense lawyer's job is to expose weaknesses in the prosecution's case, calling their own witnesses, obviously, that will get directed and cross-examined. But their job is to create that reasonable doubt. Remember, beyond a reasonable doubt is what the prosecution wants. They want a reasonable doubt. A great example is, again, the Casey Anthony case, where the defense said, the little girl drowned. Forget everything else. She drowned. It was an accident. Notice there's no proof of that. Notice there was no proof that Casey was abused. Notice there was no proof of basically anything the defense said. Why? Because they don't have to prove anything. Their job is to create doubt. Same thing with the Bernie Goetz case. The job was to create doubt that Bernie Goetz went on there with bad intentions. Instead, all they kept saying was, hey, he was defending himself. Hey, he was defending himself. And there was enough doubt there in both of those cases for those juries not to convict. So basically, you're going to create doubt, even if you kind of have to make it up. Sometimes that seems like that's how it happens. But if you can create that doubt in the defense's mind, in the jury's mind, then, again, that's part of their job. The defense, remember the disclosure term where the prosecution has to turn over all their evidence to the defense. In this case, they do not. The defense can withhold all their information until they want to show it to the jury. Again, that's probably why they don't do a whole lot of giving any information away when we have the grand jury or the preliminary hearing. They save that for the trial if they need it. For the defense, what are some of their strategies? Well, some of their strategies, obviously, you want to defend your client as best as you can. So one of the things you have to ask, do I want to put the defendant on the stand? And most of the time you do not. The defense, even if they're a well-spoken person, you don't want to put them on the stand because that's the prosecutor's job, is to get them to, give up some information. So if they're definitely guilty, you definitely don't want to put them on the stand. They may not be sympathetic. O.J. Simpson's not going to be a sympathetic character. Garrison Anthony certainly wasn't sympathetic. So those were reasons why they didn't put those people on the stand. Can their story hold up to scrutiny while they're under oath? Again, that's a question that you have to ask. Some of the other things that you can do as a defense attorney, though, are what's called defensive strategies, or primarily known as affirmative defenses. Now, the alibi is not an affirmative defense. Basically, the alibi defense is that my client was nowhere near the crime scene. They could not have done it. Easy enough, we have an alibi. Now, a lot of times, if you have an alibi and it's confirmed, the police don't even go as far as arresting you. In other cases, though, now you're on the stand. So you have what's called an affirmative defense. My client committed the crime. That's what you're going to tell the jury. But, and that but's huge, there was a reason. And that reason is going to make you decide not to find my client guilty. One of the best examples, we didn't get to see it, but there was a guy who bought a gun. He was an ex-con, and that's illegal in the state of Illinois. He saw that what he did was illegal. He turned it in the police. They turned around and arrested him and put him on trial. That really stinks. You try to do the right thing and they arrest you. But come to find out, and the defense attorney went up, told the jury, my client did it, no doubt. But there's an affirmative defense. His IQ was about 68, which, to give you an example, that's like a third grade reading level. They showed him filling out the form to actually purchase the gun. They asked him for his birthday. He put 3. They said, what does that mean? He goes, nope, just 3. He couldn't read. He could barely write. And that was proven on the stand. And ultimately the jury said, yes, somebody would have had to help him fill this out. He had no idea what he was filling out for the gun permit, and they found him to be not guilty. So that would be an example of an affirmative defense, somebody who's not capable mentally of doing it. Some other ones would be a self-defense. Obviously, the person was trying to protect themselves or someone else. Insanity, it's used often. Well, no, I take that back. It's not used often, but it's always great in the movies. Oh, the insanity defense. The reason the insanity defense is never used by attorneys is because it's very difficult to explain insanity to a juror. Most don't know or have no comprehension of what an insane person is. And so unless they've worked in maybe a nursing home where they've been around people with Alzheimer's, or actually worked in a state hospital with people that are diagnosed as having severe mental disorders, most people don't comprehend insanity, and therefore they don't buy it in the argument. They're very skeptical, so that's why defense attorneys tend to stay away from it. But it's great drama in the movies. In real life, no. It very rarely happens, and it never works. Again, juries just don't buy into it. Duress is kind of the same thing. The defendant was forced to commit the crime. Again, most people have never been under duress like that, where they feel that they would never do that anyway, and so juries don't have any sympathy toward people that basically say that I did it because of duress. The last one, though, could be an argument, and again, police officers know where the line is. We've talked about entrapment before. Remember, the police officer cannot initiate the crime. It has to be initiated by the defendant. But every once in a while, an overzealous police officer or a younger police officer will mess up the protocol, and it will be entrapment, or they were lured or coerce the defendant into committing the crime. In that case, they argue that that was on the police. As far as objections, again, you see this all the time in a courtroom drama. Here's some of the bigger ones as far as objections are concerned. Leading question, we already talked about. You can't ask the question in the question. An argument, and basically what the objection is basically think of a sporting event, and the judge is the official, and basically you're saying to the judge, hey, that other team's committed a foul. We want you to think about their foul. Is it a foul? Is it not a foul? Argumentative, you're making a statement as an attorney, not a question. Everything has to be like Jeopardy in the form of a question. Assuming a fact, not an evidence, is you're assuming the witness knows something they may not be privy to, or they may not have knowledge of, and you can't ask them something they don't have. You can't ask a regular person if they have scientific knowledge or what do you know about DNA. They don't, and you can't expect them to. One of the biggest, though, is hearsay. You cannot repeat a statement of somebody else outside of the courtroom. In other words, if you weren't privy to a conversation, if it wasn't between those people, you can't state it. So a lot of times hearsay is objected to in a courtroom. It happens quite frequently. Basically, if that person can testify to making that statement, they have to testify to making the statement. Another person can't. Even if they overheard it, even if they were standing with the group, if they weren't participating in the conversation, then generally they're considered to be a third party and cannot speak about what someone else says. Irrelevant, kind of, easy enough. Calls for a conclusion. You're asking the witness to make a guess. They can't make an assumption. They can't make a guess about something. Even if it's an educated guess, unless they're an expert witness. If they're an expert witness, they have been qualified as an expert witness, and therefore their opinion does count as fact. So they can make an educated guess, and that considered to be to the jury an actual fact. But again, that goes to your background, that goes to your job, how long you've been doing it, what considers you an expert. So that leads us to a next one. If a witness isn't qualified to be an expert, they can't make expert opinions in that case. Once we get through that, you do have what we call redirect, recross, rebuttal. So a lot of back and forth with the attorneys, helping the witnesses to explain their testimony. So when you see it in court and the attorney ends and gives this real big statement, and the juror's like, typically the other side's going to get up and say, "Hey, can you explain what you just said?" Okay, they're gonna actually explain away what they if they've said something they maybe shouldn't have. Now, it must focus on the original questions. They can't add new testimony, but it is a good way to help a witness who's maybe made a misstep or said something they shouldn't have, and explaining it or give them a chance to explain it. And then we get to the closing argument. Like the opening, like your English essay, you want to talk about everything and remind the jury of everything that has happened during the trial to refresh their memory. You're going to sum up the case. You're going to hit the jury with the strong points that you made in your argument. You're going to hammer the defense or the other side, the opposing side, with bad arguments they made so that you can really push the jury. Remember, most people, when they're hearing and sitting through things, are going to remember the first thing and the last thing that they hear. So that's why the opening and closing arguments are very, very important. And usually they reflect each other. Again, like your English essay, you're reiterating what you've already said to the jury and reminding them, this is the last thing they're going to hear. I want to remind you of all the great things we did in this case. Maybe ignore some of the bad things we did in this case. And so you're going to really try to get the jury to buy into your argument. Once that's done, then the jury will be given instructions. The judge is now going to talk to the jury about what they've heard in the case. He's going to explain, or she is going to explain the law to the jury and how the law pertains to the case, how they're supposed to put the law into the case. They have to remind everybody jury's decision must be unanimous. For 1, acquittal, or 2, a conviction, one way or the other. If the jury cannot decide, and again, the judge tries his or her best to really force that jury to come up with a decision. It's what's called a hung jury. And then they're going to have a mistrial, and the whole case is going to start all over again with a new jury, and it's really, really a long process. So judges really don't like to have hung juries or mistrials. If they feel that the jury is getting pressured from the outside, they may even do something called sequestering them. That will happen to the OJ jury, and you'll hear about that, where they can't get any outside information. And basically, they're locked in their own kind of prison for a number of months. Ultimately, what we've been waiting for in this entire trial process is the verdict. That is the decision by the jury. There has been a more recent phenomenon called jury nullifications. In this case, the jury nullifies the law, or they'll make a verdict not based on the law, but based on their feelings for the law. Maybe the law is unjust, so we're going to let the defendant go, or maybe the penalty is too severe. You can't even consider the penalty as a juror when you're deliberating. Or maybe it's the mistrust of the police. Whatever it may be, the jury just ignores the law. In this case, the judge they're within their authority to step in, and he or she, the judge, can overrule that jury's verdict and, based on a matter of law, not on their opinion, but on a matter of law. And then ultimately we get to the sentencing. We'll talk about the sentencing a little bit more next week when we get to the punishments. But basically, the defendant